Functional Area 3, Part 1, Benefits and Leaves of Absence. With the variety of state and federal laws regarding employee benefits, it is necessary for all employers to ensure that their benefit policies are in compliance. The state of California offers employees many additional protected leaves of absence opportunities other than those offered under federal law. It's extremely important for California employers to understand the eligibility for and administration of each of these specific leaves. The responsibilities covered in this section are 1. Develop and maintain compliance leave and benefit policies. For example, leave entitlements, domestic partner coverage, vacation, paid time off, and health insurance premium payment. 2. Advise stakeholders and designate employee leave eligibility. For example, California Family Rights Act, pregnancy disability leave, paid sick leave, school activities leave, KenCare, and more. And 3. Managing leave entitlement and interactions. For example, tracking the leave, the documentation for the leave, and integration of wage replacements. By offering health insurance coverage and retirement savings options, employers provide greater opportunity for employees to have a better quality of life and even save money. Some of these plans include health care plans, savings plans, and paid time off benefits. The Patient Protection and Affordable Care Act, or PHRca, requires all employers with more than 50 full-time equivalent employees to provide health insurance benefits. California employers are required to provide the same level of health insurance benefits as is required nationally. However, under Assembly Bill 1602 and Senate Bill 900, the state of California set up Covered California, which was the first insurance marketplace in the United States. Under Covered California, small employers, meaning those employing between 1 and 49 full-time equivalent employees, can purchase health insurance through its Covered California for Small Businesses, or CCSB. However, small businesses must have at least 70% of their employees participating in order to purchase their coverage as the employer, and must also have at least 51% of its workforce located in the state of California. Unlike the employer contribution percentages under PHRca, small businesses purchasing coverage through CCSB are only required to contribute 50% of the cost of coverage for its employees. Small businesses purchasing health benefits through CCSB and then crossing the threshold into more than 50 full-time equivalent employees will not be terminated from the plan and will be allowed to re-enroll in CCSB. However, employers with 50 to 100 full-time equivalent employees are considered eligible through not only coverage with CCSB, but will also be required to offer health coverage as an applicable large employer under the ALE plans. On June 26, 2015, the United States Supreme Court issued a decision regarding same-sex marriage. The decision guaranteed the right of same-sex couples to legally marry throughout the United States. This decision affected every state in the nation and required that all rights and privileges afforded to spouses be afforded to spouses in same-sex marriages. This decision came 2 years to the day after the U.S. Supreme Court upheld a lower court ruling in California that held that Proposition 8, which did not allow same-sex couples the right to legally marry in the state of California, was unconstitutional. Employers need to make sure that their plans are consistent with the Supreme Court ruling. Senate Bill 30 expands the current definition of domestic partner effective January 1, 2020. The California domestic partnership is a legal relationship available to all same-sex couples as well as opposite-sex couples. It affords the couple the same rights, protections, and benefits, as well as the same responsibilities, obligations, and duties under law as married spouses. Enacted in California in 1999, the Domestic Partnership Registry was the first of its kind in the United States. California employers are required to offer the same rights and benefits provided to all spouses to registered domestic partners. This includes making health care decisions for each other in certain circumstances, access to family health insurance plans, spousal insurance policies, sick care and similar family leave, presumption that both members of the partnership are the parents of the child born into the partnership, access to some survivor pension benefits, and the right for either partner to assume or take the other partner's surname after registration, the right to request partner support upon dissolution of partnership, and the same parental rights and responsibilities granted to and imposed upon spouses in a marriage. To become a registered domestic partner, domestic partners must be over 18, or one or both partners under 18, and have obtained a court order granting permission to establish a domestic partnership and meet the requirement of California Family Code Section 297 that they may register a domestic partnership with the California Secretary of State. Partners may register by completing a Declaration of Domestic Partnership, Form NP/SF DP-1, having both partners' signatures notarized and submitting the form with the appropriate fee to the California Secretary of State. It creates some differences between California and federal law in the administration of benefits and leave. For example, an employee requesting leave to care for a registered domestic partner under the California Family Rights Act does not qualify for leave under the Family Medical Leave Act. In this situation, an employee would be eligible for protected leave under CFRA for this instance, and can also be eligible for protected leave at a later time in the same 12-month period to care for a child under FMLA. Assembly Bill 17, which was signed into law on October 10, 2003, affected all contracts with the state of California executed or amended after January 1, 2007. Under this law, any organization, whether inside or outside the state of California, that is granted a contract with the state of California for $100,000 or more must provide the same benefits to registered domestic partners as it does to all spouses. In addition, Assembly Bill 2208, the California Insurance Equality Act, signed into law on September 13, 2004, requires all health insurance providers to extend coverage to registered domestic partners as it does to spouses. The only exemption to this law is organizations that self-insure. The California Continuation Benefits Replacement Act, Cal-COBRA, passed in 1997 and is an extension of the federal COBRA program. Cal-COBRA and the federal COBRA program provides benefits continuation after a qualifying event that ends employer-sponsored coverage. Cal-COBRA extends standard COBRA benefits to non-government organizations in the state of California with 2 to 19 employees. Federal COBRA programs cover organizations with at least 20 employees. Under Cal-COBRA, employees are offered up to 36 months of coverage continuation, whereas COBRA's offers may be limited to only 18 months. Employees or dependents who exhaust their COBRA coverage can apply for additional time up to a total of 36 months under Cal-COBRA. Cal-COBRA also has an extended period of coverage for retirees and their beneficiaries. Employees who are at least 60 years old and have worked at least 5 years with their last organization are entitled to COBRA coverage extension for at least 5 years. Former employees must have this coverage available to them until they accept another health plan, stop participating in a health plan, accept Medicare, or are at least 65 years of age. The California Domestic Partner Rights and Responsibility Act of 2003 affects the administration of Cal-COBRA and COBRA as well. A California employee's registered domestic partner would be offered Cal-COBRA coverage for an employer with 2 to 19 employees and would not be offered COBRA coverage from an employer with 20 or more employees. Employers must notify employees about the right to continue coverage when a qualifying event that results in the loss of group eligibility occurs. Employees must sign up with the health plan within 60 days of receiving notice of eligibility for federal COBRA or Cal-COBRA. Employees are responsible for the entire cost up to 102% of the group rate under COBRA. For Cal-COBRA, the cost may range from 110% to 150% of the group rate. Along with Cal-COBRA, California's Health Insurance Premium Payment or HIPP program can assist individuals that are losing their employer's insurance coverage because of their own medical condition. The California Department of Health Care Services will pay health insurance premiums for certain persons who are losing employment and have a medical condition that requires a physician's treatment. Employers must notify individuals that are losing their health insurance of the availability of HIPP. A standardized notice is available from the California Health and Human Services Agency, or DHS. This notice informs the terminated employee of the existence of the program and the eligibility requirements. To qualify for the Health Insurance Premium Payment Program, the individual must meet all of the following requirements. They must have full scope or fee-for-service Medi-Cal. They must have a medical condition that requires a physician's treatment. They must meet the cost-effectiveness analysis criteria, have a current health insurance policy that covers their medical condition, be enrolled in COBRA or Cal-COBRA continuation policy, or a COBRA conversion policy in effect or available at the time of the application. They must have a health insurance policy that covers their medical condition. They will need to apply online, upload all necessary attachments. They cannot be enrolled in a Medi-Cal managed care or prepaid health plan, county organized health system, or geographic managed care or Medicare plan. Flexible spending programs are employer-sponsored benefits that allow employees to set aside funds to cover the cost of expenses for health and wellness care, dependent care, or other qualified expenses. These programs work on an annual plan year basis and are funded through regular payroll deductions on a pre-tax basis. California law requires companies that offer flexible spending programs notify employees participating in the program of any deadline for withdrawing funds before the end of the plan year. Notices may be provided by email, telephone, text messages, postal service, and in person. The notices must be provided in 2 different forms, but only one form may be via an electronic communication. In December 2018, California announced the start of its CalSavers retirement savings program for private sector workers whose employers do not offer a retirement plan, and self-employed individuals and others who just want to save extra money. Employers with 5 or more employees must participate in CalSavers if they do not already have a workplace retirement plan in place. Employers are required to either implement their own retirement plan or sign up with CalSavers by the following dates. Employers with over 100 employees must enroll by September 30, 2020. Employers with 50 or more employees must sign up by June 30 of 2021. And employers with 5 or more employees must enroll by June 30 of 2022. For the employer, they must only offer the plan to their employees. It is not their responsibility to ensure or require that their employees participate in the CalSavers program. After registering for the program, employees will be notified and given 1 month to opt out before they are automatically enrolled. Employers will have no liability for the investment decisions of participating employees. They will not be the fiduciary of CalSavers, nor will they bear any responsibility for the administration, investment performance, or the payment of benefits earned by participating employees. In the CalSavers program, savers contribute to a Roth Individual Retirement Account, or IRA, that belongs to them. The default savings rate is 5% of gross pay, but savers can adjust this rate at any time. Savers can opt out and back in at any time, and their account remains portable. It stays with them even if they leave the workplace. In order to be exempt from the requirement to join CalSavers, employers must offer one of the following retirement savings plans: 401A, 401K, 403A, 403B, 408K, 408P, or a 457B, and register their plan with the state by the deadlines listed. If an employer does not provide their own retirement savings plan or register their organization for the CalSavers program by the required deadline, they may be subject to penalties of $250 per employee if they do not comply within 90 days of receiving notice requiring registration, or $500 per employee if the employer does not comply within 180 days of receiving the notice. This concludes Functional Area 3, Part 1.